Hello, this is for my negotiable instruments class. We are now under the topic negotiation, which is a transfer of an instrument in such form that the transferee becomes a holder. So it would depend, negotiation would depend on whether the instrument is order instrument or bearer instrument. Order instruments are negotiated through endorsement and completed by delivery. Note the use of the word "and". If endorsed in blank, it becomes a bearer instrument. Blank instruments may be converted to special endorsement by writing contract consistent with the character of the endorsement. Bearer instruments, on the other hand, are negotiated by delivery only. If endorsed specially, the person endorsing is liable only as endorser to such holder as to make title through his endorsements. Also, a holder may strike out endorsement not necessary to his title. Those endorsements who are struck out are relieved from liability. Now, when do you negotiate? For promissory notes at a reasonable time after issuance. For bill of exchange, reasonable time after its last negotiation. In a 1952 case, Philippine National Bank versus C2, respondent C2 on March 30, 1948 presented Philippine National Bank Surigao branch a check in the amount of 5,000 pesos dated March 10, 1948, payable to cash or bearer, drawn by Ganye Kiao against the Cebu branch of Philippine National Bank of Communications. So after consultation with the employees of the branch of PNB, C2 was made a general and unqualified endorsement of the check. PNB accepted it and paid the respondent the amount of 5,000. Then subsequently the check was mailed to the Cebu branch of Philippine National Bank of Communications on March 20 and was presented for payment on April 9, 1948. But the check was dishonored for insufficient funds. So the check was returned to PNB Surigao Agency, and upon receipt thereof on April 14, 1948, the bank sent a letter to C2 demanding the immediate refund of the 5,000 value of the check. Later, it was discovered upon investigation that there was delay in the presentation of the check. So C2 here refused to make the refund, claiming that there were sufficient funds when at the time of the negotiation of the check. And had it not been for the delay of PNB, the same would have been paid. But because of the delay, the drawer's funds were now exhausted. So this is the main gist of the case. So invoking the negotiable instruments law stating within what time a check must be presented. The law states that it must be presented within a reasonable time after its issue. So here the court states that indeed there was sufficient funds during the issuance of the check, and the cause of the non-payment or the Lost here was the unreasonable delay in the presentation of for payment by PNB. As the check was dated March 20, it was cashed March 13. However, it took PNB up until April 9, 10 days after the check reached Cebu, to present it for payment. So, what of these endorsements? As to persons endorsing, you have regular endorsement, which is an endorsement of a person who is a party to the instrument. Next, we have irregular endorsement, wherein the endorsement is made by a person not a party to the instrument. For example, A is a payee of a note. When A signs the note and transfers it to B, and B accepts the note. If B will accept the note if C agrees to sign the note. C here, as an irregular endorsement, becomes a guarantor of the note. As to nature and effect of endorsement, when there is qualified endorsement, this constitutes endorser as a mere assignor of the title of the instrument. This does not impair negotiability of the instrument when there is a qualification without recourse. And of course, again, we have the unqualified and general endorsement. So for special endorsement under Section 34, this limits the endorsement to a particular person and turns a bearer paper to order paper. For example, pay to the order of May. Then blank endorsement, on the other hand, turns the order paper into a bearer paper. We have here a 2006 case, Melva Teresa Alviar Gonzalez versus RCBC. This is all about an irregular endorsement setting. So this is an action for sum of money originating from RTC Makati, which decided in favor of herein therein plaintiff, now respondent RCBC. On appeal, the CTA affirmed the RTC's decision minus the award for attorney's fees. So in the end, Gonzalez needed to come to the Supreme Court on a petition for review on certiorari based on the following undisputed facts. Gonzalez here was an employee of RCBC as a new accounts clerk in the retail banking department at its head office. So here, a foreign check in the amount of $7,500 was drawn by Dr. Don Zapanta of a medical group with address in California against a Joey Bank Wilshire Center Bank based in California, payable to Gonzalez's mother, Eva Alviar. So Alviar then endorsed this check. Since RCBC gives special accommodations to its employees to receive the check's value without waiting for the clearing period, Gonzalez presented the foreign check to RCBC's head of retail banking. After examining this, uh, Olivia Gomez requested Gonzalez to endorse the check, which she did. Olivia then acquiesced to the early encashment of the check. So she practically allowed the early encashment, signed the check, but indicated that her authority is up to 17,500 only. So basically, her endorsement has a qualification. Afterwards, Olivia directed Gonzalez to present the check to Carlos Ramos to procure his signature, probably to cover her, to give her more protection. After inspecting the check, Carlos Ramos signed it with an OK annotation. So after getting the signatures, Gonzalez presented the check to the remittance section of the Foreign Department of RCBC, who, after scrutinizing the check, authorized its encashment. So, in the end, Gonzalez received 155,000 pesos, which is the peso equivalent of the 7,500 dollars. Now, RBC has the check, so it would try to collect it from the bank in California. So the same check was dishonored because of and irreg, which is also which also means irregular endorsement. So RCBC insisted again and sent back the check. This time the check was returned due to account closed. So you end up here with RBC not able to cash on the check. So what the next move would be for RCBC to get back to Gonzalez and demand for the return of the peso equivalent that she received. So here, as an employee, Gonzalez settled the matter by agreeing that the payment be made through salary deduction. So this temporary arrangement was communicated by Gonzalez to RCBC. So the deductions was implemented starting October 1987. And then RCBC sent a demand letter to Alviar, the mother of Gonzalez, for the payment of her obligation. So here Alviar did not respond to RCBC. So RCBC then convened the matter to their legal counsel. A letter was sent to Gonzalez reminding her of her liability as endorser of the subject check. So to avoid litigation, she needed to fulfill her commitment to settle the obligation, as assured in her letter. But what Gonzalez did was she resigned from RCBC. So in effect, what was deducted only from her salary was just 12,000 pesos, covering 10 months of payment. So because of this, RCBC had to file for sum of money against Eva Alviar and Gonzalez. So Gonzalez filed an answer with counterclaim, and then Eva Alviar, her mother, was declared in default for having filed her answer out of time. So that's why your regional trial court held the three defendants, including the husband of Gonzalez, liable to return the amount to RCBC plus interest. Okay, so what did our Supreme Court decide? Okay, the Supreme Court based its decision on Section 66, liability of a general endorser. Okay, so under Section 66, the warranties for which Alvar and Gonzalez are liable as general endorsers in favor of subsequent endorsers extend only to the state of the instrument at the time of their endorsements. That is, that the instrument is genuine in all respects of as what it purports to be, that they have good title thereto, that all prior parties have capacity to contract. Okay. So this provision cannot be used by the party which introduced a defect in the instrument. So remember that it was respondent RCBC which qualifiedly endorsed the same. So in effect, prior endorsers, Alviar and Gonzalez, uh, should not be held liable because the defect was done by a subsequent party. Okay, what is this defect? That defect was the qualified endorsement of up to 17,500 pesos only of Olivia Gomez, who is the employee of RCBC. Had she not qualified her endorsement, there would have been no reason to dishonor the check. Okay. So it was RCBC which caused the dishonor of the check upon presentment to the drawee bank. So Olivia Gomez cannot hold prior endorsers Alviar and Gonzalez liable on the instrument. So therefore, RCBC in this instance should bear the loss. Next, we have conditional endorsements where party required to pay may disregard a condition, but person to whom payment is made will hold proceeds thereof subject to the rights of the person endorsing conditionally. Party required to pay respect to the condition and hold payment until compliance or non-compliance thereof. We also have restrictive endorsements, which prohibits further negotiation of the instrument, constitutes endorsee as agent of the endorser. Like, for example, the use of the statement for deposit only. This vests title in the endorsee in trust for or for the use of some other person. What are the rights of the endorsee transferee? First is to receive payment of the instrument, bring any action thereon that endorser could bring, and transfer rights as endorsee to other person. That person can also strike out other endorsements. But this is applicable only for bearer instruments only. How is this made? By striking out endorsements not necessary to the title of the holder. The effect would be the endorser whose endorsement is stricken out is discharged from liability. All endorsers subsequent to him are discharged also from liability. What are the warranties and liabilities? On the maker, such person has primary obligation, admits the existence of the payee in his capacity to endorse, warrants to pay the instrument according to its tenor, that there is no need for payee or any subsequent taker first to seek payment against another party. This is called a contract of primary liability. The drawer, under Section 61, admits the existence of the payee and his capacity to endorse, warrants the instrument to be paid or accepted or both upon presentment, warrants to pay the instrument if dishonored, and this is called a contract of secondary liability. Next, the drawer acceptor admits the existence of the payee in his capacity to endorse, admits the existence of the drawer, genuineness of his signature, warrants to pay instrument according to its tenor, no need for payee to first seek payment from another party. This is a contract of primary liability. Let us take this case. This is a 2009 case between Security Bank and Rizal Banking Corporation. So two banks as opposing parties. What happened was in January 9, 1981, Security Bank issued a manager's check for 8 million pesos payable to cash. This is a proceeds of the loan granted to Gidon Construction Development Corporation. So on the same day, the 8 million check, together with other checks, was deposited by Continental Manufacturing Corporation to its current account with RCBC. Now, RCBC honored the 8 million check and allowed CMC to withdraw the same. So the following day, banking day, GCDC issued a stop payment order, claiming that the 8 million check was released to a third party by mistake. Consequently, uh, Security Bank, Security Bank dishonored and returned the manager's check to RCBC. Thereafter, the check was returned back and forth between the two banks, resulting in automatic debits and credits in each bank's clearing balance. So in the end, RCBC had to file a complaint for damages against Security Bank. Meanwhile, the Philippine Clearing House stopped returning the checks to both banks, and by way of temporary arrangement, they divided equally the 8 million between the two banks. So that means one bank has to recover 4 million from the other. So at the regional trial court, Security Bank was ordered to pay RCBC 4 million. The Court of Appeals affirmed the decision plus interest, although the attorney's fees was deleted. So you have here several issues raised, but eventually the Supreme Court settled for the following issues: whether Security Bank is liable to RCBC for the remaining 4 million, whether Security Bank is liable to pay the lost interest income on the remaining 4 million. Okay, so RCBC avers that the manager's check issued by Security Bank is substantially as good as money. On the other hand, Security Bank contends that RCBC violated the Monetary Board Resolution number 2202 of the Central Bank, mandating all banks to verify the genuineness and validity of all checks before allowing drawing against the same. So the court decided that upon review of the question check issued by Security Bank, it noted that it was not an ordinary check, but it was a manager's check drawn by the bank's manager upon the bank itself. It stands with the same footing as a certified check. So RCBC, in immediately crediting the amount of 8 million to CMC's account, relied on the integrity and honor of the check as it is regarded in commercial transaction. As the check was payable to cash, it appeared regular in its face, and the bank found nothing unusual in the transaction. So Security Bank cannot escape liability by invoking Monetary Board Resolution number 2202, because actually that resolution states that uh, RCBC may be permitted at the discretion of each bank, covers drawings against demand deposits as well as withdrawals from savings deposits. So basically, Monetary Board Resolution 2202 alters the does not alter the extraordinary nature of a manager's check relative to the rights of the parties thereto. So here eventually, Security Bank was ordered to pay RCBCD 4 million pesos with legal interest. Next, we have the payee endorser of a check who is obliged to pay the check according to its terms if the check is dishonored by the drawee. A check is dishonored when endorsee duly presents it for payment to the drawee and it is not paid. Further obligation of the endorser may not be enforced unless endorser is given due notice of dishonor. So notice the use of the requirement of due notice. This is a contract of secondary liability. Payee endorser of a note is obliged to pay the note according to its terms if the check is dishonored by the maker. Further, the obligation of the endorser may not be enforced unless the endorser is given due notice of dishonor. This is also a contract of secondary liability. Briefly, the prerequisites for secondary liability may include presentment, dishonor, and notice of dishonor. So let's go through the cases. First off, we have the 2008 case of Allied Bank versus Limsho One, Metrobank, and Producers Bank. Facts of the case: November 14, 1983, Limsho One deposited to petitioner Allied Bank in its Quintin Paredes branch in Manila money market placement for 1,152,000 for a term of 31 days to mature, evidenced by provisional receipt number 1356. Now, on December 5, 1983, a person claiming to be Lim Shou Wan called up Christina So, an officer of the Allied Bank, instructed the latter to pre-terminate Lim Shou Wan's money market placement and issue a manager's check representing placement of the proceeds. Give the check to Deborah D. Santos, who would pick up the check. Lim Shou Wan described the appearance of Santos so that So could easily identify her. So when this Deborah D. Santos arrived at the bank, signed the application form for a manager's check, the bank issued a manager's check for 1,158,000, representing proceeds of Lim Shou Wan's money. The check was cross-checked. So this is important, cross-checked for payee's account only and given to Santos. Thereafter, the manager's check was deposited to the account of Philippine Cement Corporation with Metrobank with a forged signature of Lin Showan as endorser. So when Philippine Cement Corporation deposited the money market placement for 2 million with Producers Bank, Santos was the money market trader assigned to handle FCC's account. Now, Santos addressed to Angelas of FCC acknowledging receipt of the placement. This placement was rolled over until December 5, 1983. When the placement matured, FCC demanded payment. On December 5, the same date, So received a phone call the same modus, instructing her to pre-terminate Lim Showan's placement. The manager's check be placed in the name of Lim Showan, which was deposited in the account of FCC, purportedly representing proceeds of FCC's money market placement with Producer Bank. In other words, Allied check was deposited with Metrobank in the account of FCC as Producers Bank's payment of its obligation to FCC. So, to clear the check, it has to go through the Philippine Clearinghouse Corporation. Metrobank stamped a guarantee on the check. All prior endorsements and lack of endorsement are guaranteed. Okay, so on December 9, Lim Show Wan deposited with Allied Bank a second money market placement to mature in January 9, 1984. So upon maturity of the first money market, Lim Show Wan now came to Allied Bank to withdraw it. and she was informed that the placement was pre-terminated upon her instructions. So now Lim Showan is denying having given the instructions. She desisted from further complaints when she was assured by the bank's manager that the money will be recovered. So Lim Showan's second placement matured on January 9. Lim Showan instructed So to roll over the placement for 30 days. Now, by January 24, 1984, Lim Showan realized that the promise that her money would be recovered would not materialize. So she sent a demand letter to Allied Bank. Allied refused to pay Lim Showan, claiming that there was authority. So subsequently, Lim Showan had to file a case with the RTC to recover the proceeds of her first money market placement. Allied filed a third-party complaint against Metrobank and Santos. Metrobank filed a fourth-party complaint against FCC. FCC filed a fifth-party complaint against Producers Bank. Summons were duly served to all parties, except for Santos, who was no longer connected with Producers Bank. So more than 6 months after the funding the check, Allied informed Metrobank that the signature was forged. Metrobank withheld the amount represented by the check from FCC. Lim Showan later filed an amended complaint to include Metrobank as party defendant along with side with Allied. So the RTC rendered a decision ordering Allied Bank to pay Lim Showan the amount of 1.1 million, ordering Allied Bank to pay moral damages, attorney's fees, cost of suit. Okay. So naturally, the case went up to the Court of Appeals, where the decision was modified, distributing the loss or penalties at 60% to Allied Bank and 40% to Metro Bank. Hence this petition. Okay. So as to liabilities of the parties, we have here provisions from the Civil Code, but our interest is with the negotiable instruments law. Okay, that would be section 66 of the negotiable instruments law, liability of a general endorser. And then section 65, warranty or negotiation by delivery, so forth. So the warranty that the instrument is genuine in all respects, what it purports to be, covers all defects in the instrument affecting the validity thereof, including forged endorsement. Thus, the last endorser will be liable for the amount indicated in the negotiable instrument, even if the endorsement was forged. But this general rule is subject to exceptions when the issuance of the check itself was attended with negligence. So both banks were negligent in the selection and supervision of their employees, resulting to the encashment of the forged checks by the impostor. So the court found it reasonable the proportionate sharing of 50-50%. I know this is for a reference case. Wait, here. In the instant case, the trial court correctly found Allied negligent, issuing the manager's check and transmitting it to Santos without even a written authorization. Remember that there was just a call from allegedly from Lim Showan. So Allied's negligence must be considered the proximate cause of the resulting loss. Now, this liability of Allied is concurrent with that of Metrobank as the last endorser of the check. FCC, having no participation in the negotiation of the check and the forgery in Lim Showan's endorsement, can raise the real defense of forgery against both banks. As to producer bank, it must be held liable as the employer of Santos. Okay, wait. In the instant case, Lim Showan's money market placement in Allied was pre-terminated and withdrawn without her consent. There is no reason that the proceeds of Lim Showan's placement be deposited to FCC's account. So, from the facts of the case, we see that Santos could be the architect of the entire controversy. Unfortunately, the courts have not acquired jurisdiction over her, so the court could not place any liability upon her. So, Producers Bank must be held liable to Allied and Metrobank for the amount of check, plus 12% per annum, uh, which Allied Bank and Metrobank are just to pay Lim One based on the 60-40 proportion. Finally, let's have this case: Metrobank versus Philippine Bank of Communications, Filipinas Orient Finance Corporation, Pipe Master Corporation, and Tanwan Lian. So sometime in 1978, Pipe Master, represented by UQ as its president, applied for check discounting with Filipinas Orient Finance Corporation. Filipinas Orient approved and granted the same. So Pipe Master issued a board resolution authorizing UQ as president to execute, endorse, make, sign, deliver negotiable instruments necessary in connection with any transaction course to Filipinas Orient. Don Juan Lian executed in favor of Filipinas Orient a continuing guarantee that he shall pay at maturity any promissory notes, drafts, checks, and instruments or evidence of indebtedness for which Pipe Master may become liable, up to the amount of 1 million pesos. So in the case of default by Pipe Master, Filipinas Orient may proceed against him. So in accordance with the check discounting agreement, Pipe Master Yokyo sold to Filipinas Orient 4 Metrobank checks amounting to 1 million. In exchange for the 4 Metrobank checks, Filipinas Orient issued to Yokyo 4 Philippine Bank of Communication cross checks amounting to 964,000 payable to Pipe Master with the statement for pays account only. So aside for it being cross check, there is a clear indication or instruction of for pays account only. Upon receipt of the PBCom checks, UQ endorsed and deposited in Metrobank in his personal account 3 checks valuing 721,000, while the remaining 242 was deposited to Solid Bank, also in his personal account. Eventually, PBCom paid Metrobank and Solid Bank the amount of the checks. Subsequently, Filipinas Orient presented the 4 Metrobank checks equivalent to 1 million received from UQ, which were dishonored by the joint bank. Pipe Master refused to pay the amounts, claiming that it never received the proceeds from the PBCom checks because they were paid to the wrong party, UQ, who was not the named payee. So what happened here? The regional trial court ordered Metrobank to pay plaintiff the amount of 721,000 and Solid Bank to pay plaintiff the 242,000. On appeal, the appellate court affirmed the decision of the trial court. Okay. So what the Supreme Court decide? First, they defined a check as a bill of exchange drawn on a bank payable on demand, and that they recognize that negotiable instruments law, being an old law, is silent with respect to cross checks. But it takes judicial cognizance of the practice that a check with two parallel lines on the upper left corner means that it could only be deposited and not converted to cash. Crossing the check with the phrase pays account only is a warning that the check should be deposited in the account of the payee. So here, the petitioner's banks have the obligation to ensure that the PIB becomes checks were deposited in accordance to the instructions. That is, to the account of pipe master only. What transpired was that the petitioner banks accommodated UQ. So, being a valued client is a dangerous precedent for banks. They need to make sure. So, because what happened here, because of UQ being a valued client, these banks even stamped that all prior endorsements or lack of endorsements are guaranteed. So in so doing, they became general endorsers, and as such, the corresponding warranties would subsist. So therefore, the petitioner banks being endorsers cannot deny liability. Okay, so you end up with the same decision against the banks as affirmed.